Second aspect of the Joe DiMaggio phenomenon, awfully important in a state-style jury selection. When you try a case, you are presenting to that audience in the jury box an artificial world, a representation of reality. Do you realize then that trying a case to a jury has its analog in the theater? Now, it's an important analog. It's one that I'm going to talk about again and again in the course of the day, but I don't want to be misunderstood. When I refer to theater, I don't mean razzmatazz showbiz. I don't mean, you know, Milton Berle, stand-up yaks, things of that kind. Of course not. It's much more difficult than that. A courtroom is an artificial space, just as a theater is an artificial space. The jury sits in the jury box the way the audience sits in the audience. You are working in the well of the court the way the actor works on stage. There are witnesses, there's dialogue, there are props, there are costumes. And where the audience in the theater ultimately, if the actors are successful, the audience experiences an aesthetic effect, what your audience will experience is persuasion, but they are very similar. There is much that we must learn from professionals in the theater, and I'm going to make reference to that as we move along. Right? Here's the first reference. Self-evident, but it's very important in my own experience. More than half the lawyers who try cases have to work on this. Any actor will tell you. Maybe you're going to achieve the aesthetic effect, and maybe not. But you can achieve it, if at all, only if you hold their interest. If the audience falls asleep on you, or begins to wool gather, daydream, or walks out, obviously you failed. Well, your audience in the jury box can't walk out because there's a bailiff there to keep them under duress if they try to walk out. But there's nothing that prevents them from taking a walk mentally or even falling asleep. And if you bore them, you're on your way to losing. You cannot persuade a jury that you have bored. You can't impress upon them your trustworthiness if they're not paying attention to you because you're so damn dull. You have a professional obligation, then, to be interesting. Just as to a knowledgeable observer, you could watch DiMaggio endlessly. It was just so interesting to see how he did what he did. I am nothing if not a realist. And I know that having said that you've got a professional obligation to be interesting, you're now going to wake up at 2 o'clock tomorrow morning, or some other 2 a.m., that dark 2 a.m. of the soul that every one of us sometimes experiences. And my words are going to echo in your mind. And you're going to say, Younger says, be interesting. Be interesting. I bore myself. If I bore myself, how can I be interesting to others? Yeah, I'm a realist, and I know that that is what all of us, or almost all of us, feel. We're inherently very dull dogs. Right? Now, some few of us are endowed by nature with that special quality that makes you interesting just by being yourself. I will take 2 examples, one from each of the sexes, and I deliberately choose elderly people to show you that that is so. Among men, my idea would be Cary Grant. Cary Grant walks into a room and it lights up, even though nobody's flicked the light switch, right? You can't take your eyes off the guy. You know he's alive and well, and he's 76 years old. And do you know that he cannot walk out on the streets of Manhattan in the daytime? Because riots start. The poor man wants to walk into a retail store to do some shopping, and they're going to end up calling the cops because things get out of control. That's the kind of impact he makes upon people. And on the other side, Katharine Hepburn, that's my own ideal. 72 years old. She's got 5 fatal illnesses. And I tell you here and now, and if anybody knows her, please quote me. If she will have me, I am ready to run away to sea with her tonight and never return, right? That's the kind of effect she has on me. So Cary Grant, Katharine Hepburn, that's being interesting. But if you're Cary Grant or Katharine Hepburn, well, first of all, you don't need me to urge upon you the importance of being interesting. And second, you're probably not in this room. The harsh truth is that all of us are already what we're going to be when we grow up. And if you haven't yet come to terms with it, you better. You're not going to be a movie star, and you're not going to be a basketball player, and you're not going to be, you know, I know I'm never going to invade Russia, and I'm never going to conquer all the Indies and the other things that I kind of would like to do. but you know, you gotta, you know, sort of get along with what nature or God gave you. So we'll assume that you are, just by being yourself, very dull indeed. How can you be interesting? Well, for God's sakes, you can make yourself more interesting than you are by working at it. If you leave it the way it is, this is the way it goes. Again, not realistically, but again, not that unrealistically, just to give you the hang of it. Lawyer conducted voir dire. A lawyer has a reason for asking every question. He thinks he needs this information, and this is how it's going to go. Juror number one, what is your name? Smith. Mr. Smith, are you married? Yes. Do you have children? Yes. How many? 4. Fade out. Fade back in, 2 hours later. And Mr. Smith, what does your wife's second cousin do for a living? And it's just, you know, you're jumping out of your skin by now. It's so long drawn out, and it's so tedious, and it's just so boring. The other jurors have long since turned off. The judge is reading his comic book up on the bench. It's very... If you were to pause and tap the lawyer on the shoulder and say, why are you doing this? He would say, well, I need the information. I'll grant you that. He must ask these questions. But now, look at what's available purely mechanically. Anybody can learn to do this, and it will raise the interest quotient, not to the point where you're Cary Grant or Katharine Hepburn, but to the point where at least you will be tolerable. What's the secret of being interesting? You all know, no matter how well you do anything, if that's all you do, it gets boring. So the secret of being interesting is variety. So here's how you can vary it, in 2 ways, and it operates exponentially. First way, never ask more than 3 or 4 questions of any one juror. Bounce around, by which I mean don't go mechanically down the line, bounce at random, from juror 1 to juror 4 to juror 7, whatever the mood is. It will sound then something like this. Juror number 1, what is your name? Smith. Mr. Smith, are you married? Yes. Juror number 4, do you have a license to drive a car? And juror number 7, have you ever been on a jury before? By the 3rd bounce, the jurors know that you're bouncing. First, it's interesting because of the constant variety of voices and personalities. Second, once the jurors sense that you're going to bounce, you know what, you will hear this. I don't know if you hear it, but somehow you pick it up. They straighten up. There's a little bit of extra muscular tension, and they are listening carefully, which is what you want them to do. And you know why they're listening? Because they realize that since you're bouncing, the next question may come at them. See, because it's at random. They don't know when it's going to come, and it may be the next question. They want to listen so as to be able to answer the question rather than having to say, oh, I wasn't listening, would you repeat that? Which is embarrassing in front of the other jurors. If they start to listen in order to catch the ball when you throw it to them and return it to you, they are playing the game with you, which means they are on the way to trusting you, because you must trust the other members of your team, the people you play the game with. Yet another way of varying it. Every once in a while, throw in a question to the entire panel so that you've got 2 modes of variation working at once. It'll sound something like, juror number 1, what is your name? Smith. Mr. Smith, are you married? Yes. Juror number 3, do you have a license to drive a car? Yes. Has anybody on this panel ever served on a jury before? And so on, just mixing in questions at large with individual questions in turn bounced from one to the next. Lucidity, interest, and now third, and this will pretty much wind up our discussion of jury selection, what about problems? Problems, weaknesses in the case. My Joe DiMaggio image, it seems to me, gives you a general approach to handling any kind of problem in the case. And it's this. Let me state it forthrightly, and then I'll do my best to give you some examples. First of all, you must, if you haven't already gotten used to the fact, get used to it. Every case has problems. There is no such thing as a perfect case, and you know why? There are perfect cases, but lawyers settle perfect cases because lawyers are rational, while the clients may not be. If it goes to trial, it's because it's a horse race, which means it's not a perfect case. I have twice in my life been on the bench presiding when lawyers presented a perfect case, an absolutely perfect case. Each time, the jury decided against them. Because the jurors are quite smart. They're smarter than we are. And they know that perfect cases don't exist. So that a perfect case is a phony case. Is there any more or less litigation situation that has been investigated at a greater expenditure of time and money than the Kennedy assassination. Here we are, almost 20 years later, two multi-million-dollar investigations later, and do we yet know for sure what happened? We do not. And that's the nature of reality. You can never answer questions 100%. So there will always be problems and weaknesses in the case. Where was I? Yes, my sort of approach to them. Learn to look at these problems as the jury will look at them. Use the ears and the eyes of the jurors. Forget about the judge and forget about the appellate court. See it from the jury box. And then you say to yourself, what can I, as a lawyer, do that will most vividly say to the jury, there may be a problem here, but you can trust me. I will not mislead you. I will not try to fool you. Once you put the question that way, the answer is usually obvious. That's what you do. And it's invariably the effective thing. The problem does not go away. Of course not. But you keep the jury, even though you've got the problem. And you know what the answer to the question, what can I do that will most vividly get across the idea that I'm trustworthy? You know what the answer to that question almost always is? Believe it or not. You've got a problem, tell the jury you have a problem. Lay it on the table. Don't try to pull the wool over their eyes. If there's something to be said by way of amelioration, say it. And if there's nothing that you can say to ameliorate or improve the problem, don't say it. But never, never fool the jury. And you tell the jury about your problems at the earliest opportunity. In a state court, that's going to be jury selection, voir dire. In a federal court, it'll be the opening statement. Maybe even in a state court, some on the voir dire, some on the opening statement. By the end of the opening statement, though, you should have told the jury about every single problem you have in that case. Let me take just 2 or 3 examples. I'll limit myself to 3. First, we've already touched upon it. You're trying a simple intersection collision case. Question of lights. Who went through the red light? Your guy or the other guy? Your guy was driving a yellow Plymouth, he was driving a blue Buick. You say your guy had the green light, they say their guy had the green light. John Q. Bystander happened to be standing on the street corner. He saw the cars collide. He's willing to testify, and he says that your guy had the green light. Terrific. Except he will also say, and under the rules of evidence in your state, it's going to come out, that a couple of years ago, he was convicted of burglary, and he served 2 years in the state penitentiary. That is a problem in the case, obviously. And when you are a beginner, you know what you want to do with that problem? You want to do with it what the ostrich does with problems. You want to put your head in the sand and pretend it's not there. That's kind of human nature, because there's something of the ostrich in all of us. And you say to yourself, well, he's not going to take the stand till Thursday. Maybe the sun will go nova. The world will come to an end by Thursday. See, I won't have to deal with it. Well, the sun will not go nova, the world will not come to an end, and the ostrich always manages to get caught when he puts his head in the sand. If you have not told the jury about your problem, Thursday's going to come, you put John Q. Bystander on the witness stand, on direct he tells what he saw about the accident, and then you know what happens on cross-examination. The other lawyer leaps up with the blue saliva running down his jaws. Is it not a fact that you served a term in the state penitentiary for burglary? And the jurors go, oh my God, a felon in our midst. And you're the one who called the felon. And they're reverberating to the fact that the felon has taken the stand, and they're not listening, and they're angry with you for calling a jailbird in the courtroom, etc. But if you prepare them for it by telling them about it, it has a wholly different impact. On voir dire, how do you tell them? Ask a question. To get an answer? No. To convey a fact. You remember, we used this as an example. Ladies and gentlemen, did you know that I'm going to call a witness named John Q. Bystander? No, we didn't know, but now they know. And did you know that John Q. Bystander served a term a couple of years ago for burglary in the state penitentiary? No, we didn't know. But now they know. And a lot of lawyers like to ask what I regard as a dumb third question. And the dumb third question is, will that affect the way in which you consider his testimony? They said, no, it won't affect it at all. Of course it will. That's why we're working on it now, and that's why I think it's a dumb question. It's disingenuous. I just leave it out. Now what happens when he takes the stand? If the other lawyer starts to scream that he served a term in the state pen for burglary, the jury's reaction is very different. Their reaction essentially is, what's he getting so excited about? We've known for 3 days that the guy served a term in the state pen for burglary. And you know, the longer they have to get used to something, the less ferocious it becomes. you know, known fears are not as dreadful as, or the known is less fearsome than the unknown. So they've gotten used to it, but most importantly, you have laid it on the table. I have a problem, ladies and gentlemen. John Q. Bystander is a convicted felon. I can't help that, but he happened to be there to see the accident, and you just have to accept it as such. Second, this I think is going to be very useful for some of you, and I've never seen it noted anywhere. In many civil actions and in an increasing number of criminal actions, there is going to be a need to read at length to the jury from documents. Anybody who's tried cases has run into that. In a civil case, for example, you take the deposition of the key witness. He is deposed for 40 days and 40 nights without stopping. It produces 25,000 pages of transcript, every single question and answer absolutely vital to the case, one side or the other. And because God is sometimes a pixie comedian, that's always the witness who dies. So we've now got 25,000 pages to put before the jury. I don't know that anybody's figured out a way to do it. You know, you can put a colleague on the stand, not as a witness, just as a reader, and you read the Q&A back and forth. But if you're going to have to read all those pages of transcript, you just can't do it and keep the jury's attention. It's just dull. Even worse than that is putting a corporate trust indenture into evidence. You ever done that? It can be a civil case or a criminal case. Corporate trust indenture. In New York and the other big cities, the law firms that prepare those things don't type them, they print them in type so small only an insect can read it. And you've got about 7 pages of that kind of printing. That constitutes your corporate trust indenture. You put it into evidence, the judge says received, and now you say to the judge, at least in my neck of the woods, Judge, I'd like to read it to the jury. That's all you can do, read it to the jury. The judge says, go right ahead. That's how you tell the jury what's in it. You don't give it to them in recess for 2 days while they read it to themselves. You read it out loud. And if any of you has ever had to do that, you know what an awful experience it is. You take out your magnifying glass and you say to the jury, reading from the corporate trust indenture. And you start reading, and you don't get past the first line when the jury is as much as saying to you, why does the lawyer do this to us? This is the most boring thing I've ever heard in my entire life. I'm going to sleep. And they go to sleep. Well, that's a problem in the case, and you had better deal with it early in the proceeding, which will be voir dire or maybe in the opening statement. How do you deal with it? Tell them about it, and in this instance, there is no possible amelioration. Tell them about it absolutely straight. This is, I mean, how you do it is up to you, but the essence of it would be this. In the voir dire, or the opening statement. Ladies and gentlemen, I want you to know something. By my calculation on Thursday, I will be putting into evidence a piece of paper lawyers call a corporate trust indenture. Now, never mind what that is. We'll explain it later. For now, I want you to know just one thing. When it goes into evidence, under the rules in this court, I am required to read it to you. And that's what I'm going to do. I'm going to read it to you out loud. And it's going to be the most boring thing you have ever heard in your entire life. There's just nothing I can do about it. That's the way it is. Right? Now it's Thursday. What happens when you start to read with your magnifying glass from that corporate trust indenture? It's as if they're saying it to you. It goes this way. This is the... Hey, wait a minute. The lawyer told us it would be boring. We're in good hands. Let's go to sleep. You see, I am a realist above everything. Of course they're going to go to sleep. Nothing can keep them awake. But do you see the difference? If you don't tell them about it, they go to sleep angry with you. If you do tell them about it, they know they're in good hands, as they say to themselves. They go to sleep confident that you will wake them up when it's time to get up. Third, and I do yield to the temptation to give myself 2 minutes to talk about this because it's a favorite of mine, but I cannot honestly pretend that, indeed honestly, I cannot pretend that very many of you are going to need this. If you're young, if you're early in your career, maybe you're going to need it. But if you're getting on a bit, no, it's past the time when you're going to need it. But I am giving you something that really happened to a friend of mine. I'm making it a little bit simple, but this was the problem. This friend of mine, or perhaps one of you, got out of law school maybe a couple of years ago, and you desperately want to be a litigation lawyer, and you're working in a firm where litigation is the practice, be it a private firm, DA's office, whatever it may be. And of course, you don't start trying cases. You start by seeing how you prepare, argue a couple of motions, take some depositions, etc. You've been working on a case with the boss. You've really done all the work, but the boss is going to try it as usual, or so you think. The jury is to be selected tomorrow morning. It's now 4 o'clock in the afternoon of the day before. The boss calls you in, and he says, Charlie, you've done good work for 2 years. You've prepared this case. You know it as well as anybody can know it, far better than I will ever know it. It's time for you to solo. You are going to try this case. I haven't told you until now because you'd get too nervous. So now you just have overnight to be nervous about it. To make sure that you manage it somehow, Charlie, I'm not going to be there. See, you're on your own. If I'm there, it just makes the situation all the more tense. And I tell you, Charlie, come back 4 days from now. Tell me you won it. Tell me you lost it. But tell me you got through it. Goodbye and good luck. See you on Thursday. Oh, by the way, Charlie, I got a call from the other side a couple of hours ago. They're ready to go. They'll see you in court tomorrow. But they're calling in special counsel to try it. So you'll meet him for the first time tomorrow. It's now tomorrow. Charlie walks into court to pick the first jury in his life. And he looks over at the other side of the table. And you know who's there for the other side? Edward Bennett Williams. Now, most of the time, in my personal view of it, you don't try the case against the other lawyer. That is to say, you don't talk about the other lawyer to the jury. It's just a matter of style. I don't like to attack the other lawyer. I don't want him attacking me. I don't refer to him. You present the case as if he's invisible. The truth is the lawyers have everything to do with it. But as a question of style, I don't like to seem to be contending with the opposing lawyer personally. But where the contrast in skill or experience is as great as it's going to be here, I think you'd better deem it a problem in the case. Which means what? Use my DiMaggio approach. It's a problem, yes, but the problem almost goes away if you tell the jury about it. Associate them with your problem. And don't mince words. You can't fool them. Don't make it any better than it is. Tell them in whatever way is natural to you. Now, I'm no longer 25 years old, so it's no longer natural to me, but doing my best to pretend that I'm 25 years old, and assuming he was first up. See, he was the plaintiff, and Williams was sitting there for the defendant. It went something like this, or I think it would go something like this today. Good morning, ladies and gentlemen. My name is Irving Younger, and I represent the plaintiff in this case. Have you seen who's here to represent the defendant? Ladies and gentlemen, that's Edward Bennett Williams. That's the most famous lawyer in America. And he's the most famous lawyer in America because he's the best lawyer in America. That's who's here to represent the defendant. Look who represents the plaintiff. Now look, I'm not much, but I'm everything the plaintiff has. And if you're going to decide this case as if it's a contest between me and Mr. Williams, I'm going home right now because I cannot win that contest. So, but you understand, don't you, that no lawsuit is a contest between the lawyers? Of course not. It's not a contest. It's a dispute between the plaintiff and the defendant, not between the lawyers. And it's got to be decided not in accordance with the skill the lawyers may have or not have, but in accordance with the evidence and the law that the judge explains to you. You understand that, don't you? Well, I can tell from the expression on your face that you do understand it. So, listen, I'm not going to go home. I'm going to stay, and I'm going to do my best, even though it's not very good. Because I know that you'll decide the case, not because of my mistakes, but on the evidence and the law. And now, you see what I meant when I said associate them with your problem? Every time you screw up in the course of that trial, what does the jury say to themselves? He's doing it again. but he told us he would. He's not very good, but he's an honest man. And that's the most important thing to get across to us, to them. Before moving on, let me raise a question that otherwise would be raised afterwards. Suppose you are Edward Bennett Williams on the receiving end of that. What do you do? And my answer is that if you're Edward Bennett Williams on the receiving end of that, you will know what to do. In the printed pamphlet, ladies and gentlemen, at the end of the section on jury selection, there is a lengthy checklist, 17, 18, 19 items long, of matters on which to try to acquire information. And you might acquire that information sometimes simply by asking on voir dire, but more frequently simply by observing, by looking at the jury slip, etc. I don't want to review that in its entirety. It would take too long, but there are 3 or 4 matters where I think I ought to supplement what's in the printed materials. First, everybody knows, even the merest beginner, that you want to find out whether the juror is familiar with the litigants, the lawyers, the witnesses, etc. Frequently overlooked is the fact that many lawsuits, civil and criminal, involve a particular physical location in the city. And what is overlooked is the question, does any juror know that location? Does any juror drive past that intersection? Does any juror do business in that branch bank that was robbed? Whatever it may be. Find out whether a juror is familiar with the location. Now, standing alone, nothing cuts either way. It's just a factor that you want to take into account. You see, if a juror has personal knowledge of the layout of the branch bank or the nature of that intersection, that juror's statement in the jury room will carry a special authority. Whatever he tells the other jurors will believe. If he says, for example, I've got an account in that branch bank and you cannot see the front door from the 4th position at the line of teller's windows, the other jurors will accept that unthinkingly. So find out whether any juror knows something about the physical location, wherever it is on the checklist, just points I want to add. Assuming a state-style voir dire, there is a formula that I urge you to adopt, or adopt some variation of it, when you question male jurors. There's nothing to laugh at here. It's just a recognition that because of the times, there is a shift in the way many people view the role of women in society, and it's possible that you may irritate some people on that jury box if you say some things that they think you ought not to say. The virtue of this formula is that if anybody says anything off base, you don't say it, the juror says it, so that they're angry with him, not you. It is a formula, a locution, that you use whenever you are questioning a male juror, and it goes this way. Sir, are you married? And if the answer is yes, the very next question, without fail, should be, what kind of work does your wife do? You see, it's not logical. You've skipped over the intervening question, which is, does your wife work? Skip over it. Go to what kind of work does your wife do? And you see why. If the answer is, oh, she doesn't work, she just stays home and takes care of the house and the 7 kids, he has said it, not you. And you want to make sure that you're not the one to have somehow stumbled into saying something of that sort. Next. Look for the signs of less than good health. You pick this up by observation. Now, obviously, a disastrously sick juror is not there. The judge has sent him home or he's in the hospital, he's been excused. I'm talking about those things we all recognize, though it's hard to put them into words. The sallow complexion, the bloodshot eyes, the shifting that indicates physical discomfort. Somebody with a heavy cold. Someone who maybe is experiencing, I don't know, a mild ulcer attack or something of that sort. That has to be considered in 2 ways. If the juror is not in very good health, he may find it physically difficult to sit through the trial. In short, what would otherwise be not an unduly protracted trial may for this juror be too protracted. Normally he'd have no trouble with a 2-day case. But a 2-day case may be hard for him given that he has a heavy cold or a painful sinusitis attack. And remember that A case can be not only demanding temporally with respect to time, it can be demanding emotionally in accordance with the issues presented. A half-day trial is not terribly demanding by the clock, but if it's a child beating case or a statutory rape case, the issues may take a lot out of you emotionally, and a juror who's not feeling very well may find it hard to deal with that. Remember also that a juror who's not quite in good health may be able to sit through the trial, but chances are in the jury room will vote his conscience, to be sure, but he will not participate actively in the discussion. That's one of the consequences of diminished vitality. He's a voice, he's a vote, but not a voice. And you want to have a sense of how that may affect what the psychologists like to call the small group dynamic of how those 6 or 12 people will work things out. Next, you pay attention to the relations between ethnic groups and racial groups as well. Now here, we've got only hunches and rules of thumb to go on, and it will vary from community to community depending upon the ethnic background of the community. Obviously, in Minnesota, the Civil War is an aspect of history that figures in one way. In Mississippi, it figures another way. Race relations is one thing in Dubuque, Iowa, and quite another thing in Manhattan or the Bronx. Now, again, these are stereotypes, but you've got to take them into account because, as I said before, the stereotypes exist precisely because there is some truth to them. Let me run through some, and please understand, nobody can prove this with a slide rule. It's just the kind of thing that you've got to bear in mind. In addition to being something of a postmaster and something of a librarian, you've got to be something of a modern historian. You've got to be familiar enough with the history of European politics in the 20th century to have a sense of who dislikes whom. I start with an easy example simply because it's probably foreign to most of us, so it doesn't, touch the nerve. Your client, by reason of surname and appearance, is obviously of Greek ancestry. On the jury is number 4, who by appearance and surname is obviously of Turkish ancestry. Do you know that these days Turks and Greeks hate each other, right? Without exception? You must know that, and it seems to me that you've got to get rid of that Turkish juror. I'd even try for a challenge to the favor. I'd argue to the judge that you can almost take judicial notice of the kind of hostility that exists between these two ethnic groups, and you just can't, as a matter of discretion, let him stay on the jury. And if that doesn't work, a peremptory challenge. Now, a little bit closer to home, at least in a place like New York or Chicago. Here is juror number 5, Mr. Weinberg, about 75 years old, and he's got the numbers tattooed on his forearm. And here is your client, also about 75 years old. His surname is German, and his head is shaved clean, and he's got the roll of fat at the back of the neck, and he obviously spent the years from 1937 to 1945 torturing people at Auschwitz. I guess you'd better not let Mr. Weinberg stay on that jury, for reasons that I need not draw a picture of. And now, from comedy to tragedy, well, I guess it is tragedy. It is the American tragedy race. There are some extraordinary phenomena apparently at work in a place like New York City, which has a very large black population, an increasing middle-class black population, but an awful lot of very poor black people. And the consequences of this in jury selection and the way juries react to cases, not at all what someone who's white and middle class would expect. Now, I'm just reporting to you what my friends tell me as sort of the way cases generally go. Criminal case, client is black. You don't want blacks on the jury. It's death to have blacks on the jury. You are guaranteeing a conviction, assuming no claim of police brutality or something of that kind. It's a race-neutral case. I mean, the guy is just charged with being a heroin pusher. You don't want blacks, and you know why? This is just figuring it out. I think it's right, but I can't be sure. Any black who shows up for jury duty is a middle-class person. Essentially, the jury lists are the voter registration lists. Very poor people and very rich people don't register to vote, so this is middle class. You know, he's a school teacher or a bookkeeper, something of that kind. Where does he live? Harlem or the South Bronx. Which means what? The victim of black crime is this man and his wife and his children. And if you read the newspapers carefully, you will observe that black neighborhood groups in places like Harlem and the South Bronx are as right-wing as you can conceive of. Don't think for one moment that they believe in MAP against Ohio. Their attitude is that the cop on the beat knows who is selling heroin in the junior high school schoolyard, and why the hell doesn't the cop walk up to him and put a bullet between his eyes? That's what they want to know, because they are the victims of it, not the people who live in Scarsdale and Bronxville and so on. So you don't want blacks on the jury. In a personal injury case, you got a black plaintiff, you want a lot of money, get blacks off the jury. A black is not going to vote for the defendant, but he's not going to give you a lot of money. They have just a different view of the value of money. The ideal juror in that black defendant criminal case or the black plaintiff civil case is a highly educated, prosperous, upper middle class white person with feelings of racial guilt and kind of the making up idea. You know, we got to make it up to this person, comes out in the verdict. What do you do with two black people on the jury? You've got plenty of peremptories, and for perfectly honorable reasons, you think you ought to get rid of one of the blacks. So you get rid of him. What does the remaining black think? Remember, race is obvious. In the jury room, he will be one black with 5 or 11 whites. Will he be resentful? Will he feel that you've put him on the spot? Maybe he's going to be so resentful that you got to get rid of him, which means what? You seem to be working for an all-white jury. What will the white jurors think about that? You've got some problems there, and there are no real answers to them. Let me turn at this point, and this will complete our discussion of jury selection, to a couple of cases that many of you know about, all of you must know about, and please note them down because they were decided after the pamphlet was printed. Do you remember that an hour and a half ago I said that it's the nature of the peremptory challenge, or at least it has been for 8 centuries, that the reason which underlies the exercise of the peremptory is private to the lawyer. You have a reason, of course, but you don't have to tell it to the judge because the judge has no power to be a Monday morning quarterback. The judge cannot say to you, that's an improper or an unlawful reason. I will not allow you to exercise the peremptory on that basis. So long as you are within the numerical limits, you can exercise a peremptory for any reason you want. Now, in Swain against Alabama, going back 20 some odd years, you don't need the citation for reasons you'll hear in a moment, the Supreme Court, Earl Warren, Chief Justice, opinion by Byron White, had a case coming up from Alabama in which the claim was that blacks were being bounced by a prosecutor through use of the peremptory challenges. See, they were in the jury pool, they ended up in the jury box, and then within the numerical limits, he was able to use peremptories to get rid of blacks. And the claim was that this violated due process, 14th Amendment due process. The Supreme Court said that the claim was bad because the very nature of a peremptory is that you can use it for any reason. And if I may quote Byron White, he said you can use your peremptory within the numerical limits of the number of peremptories that you have. You can use your peremptory to get rid of all blue-eyed people, all accountants, all white people, or all black people, as you wish. That has traditionally been the view of the nature of a peremptory challenge. And that's still the law. Insofar as federal due process is concerned, there is no such thing as an unlawful peremptory. But that began to change, not as to federal law, as you'll hear, but as to state law, 3 years ago, 1978, when the California Supreme Court decided a case called California against Wheeler, 583 Pacific 2nd, 748. 583 Pacific 2nd, 748. Here's what that case was all about. Wheeler was on trial for murder. He's black. The prosecutor appeared to be using his peremptories to get rid of all black jurors. Defense counsel said, I object. I think he's using it to get rid of all black jurors. The trial judge said to the prosecutor, do you want to tell me the basis upon which you are exercising your peremptories? And the prosecutor responded, I think properly, the way I would have responded. He said, with all respect, I decline to answer Your Honor's question. I'm not going to tell you the basis on which I'm exercising my peremptories because I don't have to. The reasons are private to me. And the judge, bless his heart, said, you're absolutely right. You don't have to answer my question. Let's just go ahead. The defense objection is overruled. They ended up with an all-white jury. Conviction. reversed by the California Supreme Court, holding, 1, the basis of the decision is not the due process clause of the 14th Amendment. Swain against Alabama forecloses that. The basis of the decision is the state law guarantee of a jury drawn from a cross-section of the community, a guarantee which exists in every state's law, either by case law, by constitution, or whatever. Under that provision of the California state constitution, it was unlawful for the prosecutor apparently to challenge blacks simply because they are blacks. Conviction reversed, new trial ordered. Now, you might say, well, it's California. It's a long way away. Interesting, but it's not authoritative in Minnesota. More realistically, we speak in the room, you might remember what was going on in California with respect to the Supreme Court in 1978. They were all being indicted or something, and so they were distracted. And in any event, we know that the California Supreme Court is made up of a bunch of flakes, and you just can't trust their decisions. So that the other case I want to cite to you is perhaps more important. This is Commonwealth against Soares. I don't know how to pronounce it. It's spelled S-O-A-R-E-S. It is a decision of the High Court of Massachusetts, which they call the Supreme Judicial Court, the SJC, reported at 387 Northeast 2nd, 499. 387 Northeast 2nd, 499. Now, several years ago, you may recall this from the newspapers, the Harvard-Yale game took place in Cambridge. Harvard beat Yale, so the football team went out to celebrate, the Harvard team. They went down to that combat zone, a kind of modified red light district in downtown Boston, and they drank too much and they got into a fight, and at the end of the fight, one of the team members was dead, having been knifed to death, apparently by Soares. Soares is on trial for that murder. He is black. The prosecutor is apparently using the peremptories to challenge black jurors. Defense counsel objects. The judge says to the prosecutor, you want to tell me what you're doing? The prosecutor says, no, I decline to answer. The judge says, that's right. Objection overruled, let's go. It is buried in a footnote, but it's a curiosity worth remarking upon. The jury actually selected was not all white. It was 11 white, 1 black. The black selected to be the foreman. So you had a black foreman and 11 white people. Conviction reversed by the SJC expressly following that Wheeler case in California. The basis of the decision is the state law guarantee of a jury drawn from a fair cross-section. And the holding is that a peremptory used solely on account of the race of the prospective juror is unlawful. That's not proper. So, sent back for a new trial. I'm in the midst of rather a study of this stuff. Without belaboring it, let me tell you where we stand. If you were to go to the library, or these days to Lexis, you would find that those are the only 2 high court decisions. There are 2 intermediate appellate court decisions, one in New York and the other, I think, in Michigan or Ohio, and a fair number of trial court decisions. The majority, and a considerable majority, say that there is such a thing as an unlawful peremptory challenge, one based upon considerations of race, following those 2 cases. The minority of the cases say, no, this is hogwash. It may be law for Massachusetts or California, but not here. Obviously, though, the issue will come up with ever-increasing frequency. Observe the questions which are totally open. We just don't know anything about them. First, is this limited to criminal cases? If it's limited to criminal cases, is it limited to homicide cases? Assuming it's limited to criminal cases, does it apply to the defendant's peremptories as well as to the prosecutors? The very different considerations are involved. Does it involve matters other than race? One case, a trial court decision in New York, extends it to matters of religion. The defendant is named Shapiro, and the prosecutor is getting rid of all the jurors with Jewish surnames. Defense counsel objects, and the judge says, damn right. Under the Wheeler case and the Soares case, you can't do this. So it extends to religion as well as to race. Assuming that the jurisdiction follows the rule of the Wheeler case and the Soares case, can the prosecutor avoid this problem by answering the judge's question? Judge, yes, I'm challenging black people because they are black, but my hunch is that blacks will not be sympathetic to the prosecution's view of this case. Is that enough of an answer? Or, Judge, I have a feeling that black people just don't like me. Or, Judge, I have difficulty communicating with black people, and my job as an advocate is to communicate. Are those enough satisfactory answers to the question which, remember, in both of those cases was never answered? Mr. Prosecutor, what's the basis of your peremptories? So there's a couple of generations of litigation ahead of us on this point, but it's going to come. There's no doubt about it. Be aware of it, and we will move on to other matter. We've got 15 minutes. Let's use them, and I tell you that we are right on schedule. Once the jury has been selected, from the jury's point of view, the jurors go to the cloakroom, hang up their coats and hats, and maybe sit down and have a cigarette. The next thing will be the opening statements. From the lawyer's point of view, that's not the next thing at all. There are perhaps as many as 5 matters that must be attended to early in the trial. Maybe before the jury selection, maybe after the jury selection, but at a minimum before the opening statement. So let's talk about those 5 matters now. We won't do all 5, we'll do maybe 3 of them before we go to lunch. We'll finish up after lunch, and then we'll go on to the opening statement. These 5 matters constitute a kind of checklist, things to consider taking care of. First, in all civil actions, you should prepare marked pleadings and take them with you to the final meeting with the judge before the jury is selected. Depending upon your calendar system, it may be just, I don't know whether you've got an individual calendar or whatnot, whether it's an old-fashioned general calendar organization or an individual calendar, there is that final huddle with the judge before the case goes ahead. Take the marked pleadings with you and submit them. Now, here I pause to ask a question to which I would like a response. A show of hands. I do this every time. I'll tell you why after I get the response. I'm now discussing marked pleadings. How many of you know what they are? Okay. A very few hands went up, and that is always the response. Virtually nobody has heard of marked pleadings. Now, I have news for you. I haven't had a chance to look at the Minnesota statute or the local rules of your federal court, but I am fairly confident that the local rules of your federal court require marked pleadings to be submitted, and the onus is placed upon plaintiff's counsel in every civil action. That's in the local rules of every federal court I've ever had occasion to look at. As to your state court, well, in New York, we have a statute, the Civil Practice Law and Rules, the equivalent of the Federal Rules of Civil Procedure. In the statute itself, marked pleadings are required to be submitted by plaintiff's counsel, and yet most lawyers don't know about them. They're not aware that the rule or the statute requires it. The lawyers grow up and become judges. The judges, therefore, don't know about it just as the lawyers don't know about it, and it goes uncomplied with. Whether or not your local rule or statute requires marked pleadings, I urge you to make it part of your personal style. Prepare them and submit them, even if they're not required. I'll show you why in a moment. Since the invention of the Xerox machine, or the equivalent, it is the work of 2 minutes and the expenditure of no more than $1 to prepare marked pleadings, and they can do a lot for you. So let me take a moment to tell you how you prepare them, what they are, and then what you do with them at that final huddle with the judge. A day or 2 before the final huddle, pull out your file copies of the pleadings. So it's only in a civil action, and remember, the pleadings are the complaint, the answer, the reply, if there is one, a bill of particulars, if there is one, and under the local rules of some federal courts, the answers to interrogatories, if not terribly voluminous. All of that will be deemed to be pleadings for purposes of marked pleadings. If you don't have extra copies, run them through the machine to make copies. So you end up with a complete set of the pleadings, but they're extras, so we're going to give them to the judge and forget about them. You've got the pleadings. Now let's mark them. The complaint, remember, consists of numbered allegations, to each of which the answer makes response. The responses you'll find in the answer will be any of three. It's either admitted, expressly or by silence, or denied, or the allegation that usually runs, the defendant lacks knowledge and information sufficient to form a belief as to the truth of the allegations of paragraph 3. The universally used abbreviations for those three responses are A for admitted, D for denied, and DKI for I lack knowledge or information. In the left-hand margin, next to each numbered paragraph of the complaint, in your own hand, put in big bold block letters the letter or letters representing the matching response in the answer. So that next to paragraph 1 of the complaint might be A for admitted. Next to paragraph 2, D for denied. Next to paragraph 3, DKI. Takes a few seconds to do. Now turn to the answer. If it contains a counterclaim, remember that a counterclaim is functionally a complaint, to which the plaintiff makes response in the reply. So do the same thing. Mark the allegations of the counterclaim with A, D, or DKI as may be appropriate. You've now marked the pleadings. Assemble them as follows. Complaint on top, answer underneath, reply underneath that, bill of particulars if there be one underneath that, and if you're submitting answers to interrogatories, they're at the bottom. Staple it into a litigation back, put it in your briefcase, and take it to that last huddle with the judge before the case starts. Now, assume it's a jurisdiction which by rule or statute requires marked pleadings to be submitted by plaintiff's counsel. And that's typical. Suppose the judge knows about the local rule or statute. At that last huddle, the judge will turn to you, if you are plaintiff's counsel, and say, "Counselor, may I have the marked pleadings?" And it makes you feel warm all over to be able to respond, "Of course, Your Honor." And it does not make you feel warm all over to be obliged to respond, "Marked pleadings, what are they?" If you are defense counsel, you have prepared the marked pleadings also. Now, it may be superfluous, but maybe not. Here's the situation in which it won't be superfluous. You've got it, the marked pleadings in your briefcase. Plaintiff's counsel says, "Marked pleadings, what are they?" That's one of the rare instances when you interrupt, you volunteer. And if you're going to do it with a certain panache. Huh? You reach into that briefcase and you pull them out and you say, "Permit me, Your Honor." And you see, your legend starts to build right there. And one of the reasons you engage in this crushingly difficult work is for reasons of ego. You want to develop some kind of a legend, and there you are doing it. Now, suppose you are plaintiff's counsel, you've got the marked pleadings in your briefcase, and the judge doesn't know about it, right? So now you say to the judge, sometime in the course of that final huddle, "Judge, permit me to submit the marked pleadings." And the judge's response is, "Marked pleadings, what are they?" He looks and he sees that they are very handy for the judge. You know why? These are not the file copies. The judge can mark them up, he can write on them. The fact that they are marked with AD, DKI gives him a bird's eye view of the issues in the case right away. He's got the bill of particulars, and some answers to interrogatories may be right there in front of him, so he has the answers to some questions of evidence that may come up, of information, of facts of the case, I mean. Very useful. And if you submit them to a judge who has never heard of them, the judge may well decide that this is so useful that in the next case, he will require the lawyer for the plaintiff to submit the marked pleadings, even if there's no local rule. And so you have been the origin, the source of a new custom in that court. And that's a nice position to be in. All right, so much for the marked pleadings. Before we go to lunch, let's talk at least about one other, and that will be the trial memorandum. And my advice is that you submit a trial memorandum in every single case. State, federal, civil, criminal. You want to develop the reputation of being the sort of lawyer who always has a trial memorandum for the judge. Now, I recognize, of course, that not every case involves millions of dollars. If you're trying a case that involves a $250 property damage claim, it's awfully difficult to justify expending $500 to prepare a case in which a 100% victory is $250. Well, my experience of the trial memorandum is this. The briefer, the more succinct it is, the more useful to the judge. For that reason, I would submit a trial memorandum every time, even if I have to pay for it, meaning I do it on my own time or I don't charge it to the client or whatever. I'm doing it for myself, not for the judge. And a 2-page trial memorandum will, in 95 cases out of 100, be more than adequate. 2 pages, not 150 pages. Indeed, a 2-page memorandum is better than a 150-page memorandum, because the idea of the trial memorandum is not to persuade the judge. It is simply to inform the judge of what may be coming along. There is no standard format for a trial memorandum, but to give you some idea of what you do, and you can adapt this, change it in any way that makes sense. In the couple of minutes that we have, let me talk through a trial memorandum, or the form of one, that I think would suffice in virtually all cases. We'll assume that this is a trial memorandum for the plaintiff in that intersection collision case I've already referred to. Your client, driving a yellow Plymouth, collided with the guy driving a blue Buick, and somebody went through the red light, and you've got some PI and some PD claims as well. Okay, that's it. That's the case. All right. Caption. Plaintiff's trial memorandum. First paragraph, 2 sentences. First sentence. In plain English, tell the judge what the case is about. This is an action for damages for personal injuries and property damage arising from a collision that took place at the intersection of Main and Market here in the city on whatever the date is. Something like that. Second sentence. Tell the judge your position in that case. It is the plaintiff's position that the collision occurred because the defendant did not observe the red light. I can do that better. Because the defendant did not stop for the red light. It's plainer English. That's it. Next paragraph or section. List the witnesses you are going to call by name in the order in which you are going to call them, and in a sentence or so, summarize the testimony you expect to get from each one. So that the trial memo might continue as follows. The plaintiff will call 3 witnesses, colon. John Smith will testify blah, blah, blah. Mary Brown will testify blah, blah, blah. And William Green will testify blah, blah, blah. Next section. Not always, but only when appropriate. If you anticipate that during the testimony of one of your witnesses, there will arise a problem of evidence requiring a ruling from the bench, which problem is out of the ordinary. This is what you do for the judge. The paragraph has essentially 3 sentences. First, identify the problem. Tell the judge what's going to happen. So, the judge has just read your summary of the testimony of the 3 witnesses. This section might continue as follows. We expect that during the testimony of William Brown, the question will be asked, what color was the light? And the answer will be, well, I didn't see it, but my wife cried out, my God, the light is red. We concede that this is hearsay. That's the problem. Next, state your position. We urge that the hearsay is admissible as an excited utterance. And finally, if you've got a case or a statute, cite it. And that's all you do. Don't argue it. That will be later on. Now, just give the judge enough so that he will be informed when the problem arises. But please limit this to things that are out of the ordinary. Don't belabor the judge with leading question learning and things of that kind. That's garden variety stuff that nobody thinks that much about. But the excited utterance exception is a little bit out of the ordinary, so you want to flag it for the judge. Next section, only maybe 2 out of 5 briefs. If there will arise a problem of substantive law, other than evidence, which will require a ruling from the bench, which problem is out of the ordinary, do the same thing. Identify it, state your position, cite a case. Final paragraph, it's boilerplate, but always put it in. Tell the judge what you want. What are you going to ask for at the end of the case? What's the verdict you will request of the jury? Paragraph, at the end of the trial, we will ask the jury for a verdict in the total amount of $500, whatever it may be. then however you sign it off in Minnesota, Love and Kisses, Smith and Jones, or whatever, right? And you give it to the judge. Of course, you serve your adversary simultaneously, and that's the trial memorandum. I'll tell you, you don't even have to put it in the cover. You staple it in the upper left-hand corner. That's good enough. Typed, of course. In double-spaced typewriting, the memorandum I have just talked about, which will suffice in 95% of your cases, will not exceed 2 pages. So why not have it in every trial? Just be the kind of lawyer who always has a trial memorandum for the judge. That's 2 of these 5 matters that you consider attending to early in the trial. First, marked pleadings. Second, the trial memorandum. Well, we've said what we can afford to say on them. Let us turn now to the third of the 5, what I like to call cleanup motions. I don't know of any other expression for them. If meaning does not immediately leap to your mind, let me give you an example or 2 and you'll have it. Cleanup motions should be considered in every civil trial. It was my style when practicing, and again now, to do anything that I could do. So there is no custom as to who handles the cleanup motions. On the principle that I will do anything that I can do, whichever side of the case I was on, I made it my business to attend to the cleanup motions. Here's what you have to attend to. In every civil lawsuit, you can take it for granted, no matter how favored your state, that a rather lengthy period of time passes between pleadings and discovery and being reached for trial. It may well be then that what was true as of the time of the pleadings or the discovery is not true when you reach the time of trial. The cleanup motion is the motion you make to correct the record, to rectify whatever the passage of time has made untrue as of the day of the trial. A couple of examples to drive it home. By the way, these motions are made on the record, but never on papers. Typically, if you're going to make the motion, you'll have consulted with your opponent, and invariably it's on consent. This is not the kind of thing that you have to fight about. For example, you're in court, the jury is not there, though the court reporter is taking it down, so we're on the record. You might say to the judge, Your Honor, you will have observed from the marked pleadings that I submitted yesterday that the caption of this case is John Smith, an infant, by Mary Smith, his mother. Because at the time the lawsuit was commenced, Your Honor, John Smith was an infant, and under the statute, his mother sues as his next friend. Well, Your Honor, you know, we've got a lot of calendar congestion in this state, and there's been a long time since we went on the calendar. We've been waiting to be reached for trial. Your Honor, John Smith is no longer an infant. As a matter of fact, I'm assumed that probably during this trial, he will become a grandfather. That being so, Your Honor, might the caption be amended to read John Smith, plaintiff, against the defendant, dropping any reference to his mother? I believe this is on consent. Granted, and it's done. Watch the bill of particulars. You know what that is. It's the specification of making specific what is otherwise a general allegation in the pleading, especially the damages. The damages tend to be inaccurate as of the time of trial, though of course accurate as of the time of the bill of particulars. If Your Honor will refer to the marked pleadings I handed up yesterday, at the bottom of the packet you will see the bill of particulars. The bill of particulars says that the medical expenses incurred by the plaintiff in this case are $300. And that was indeed so as of the time of the bill of particulars. But, Your Honor, that was 5 years ago. Since then, the plaintiff has incurred another $200 of expense. Counsel has known about it for a long time. He has bills, the canceled checks. Your Honor, I believe on consent. Might paragraph 3 of the bill of particulars be deemed amended to read not $300, but $500? On consent, granted. There are your cleanup motions. Fourth, in every jury trial, civil or criminal, state or federal, I urge you to make use of a procedural device every trial lawyer knows of, but very few trial lawyers understand the full implications of this device. The device is that of the request to charge, the paper in which you ask the judge to say certain things to the jury in the judge's charge at the close of the case. I know that you have requests to charge in your practice. Conceivably, you call it something else, but every state, every federal court has them. You typically submit your request to charge very early in the trial, sometimes at that last huddle before you pick the jury. The request to charge, every lawyer knows, is the device whereby you, the lawyer, participate in framing the legal issues in the case. Everybody knows that. Let's take an example. You represent the plaintiff in a products liability case. Now, what theories are available to you? First, negligence, of course, but that requires proving carelessness, and maybe you can't prove it. Second, breach of express warranty, maybe. Third, breach of implied warranty of merchantability under the Uniform Commercial Code. Yeah, you've got that. But fourth, how about strict liability in tort? What is that? Section 402A of the Restatement Second of Torts. From the plaintiff's viewpoint, that is the most favorable theory. Is it part of the law of your state? Well, let's just assume that you go to the library and discover that there's no answer one way or the other. It has never been raised in your state. It's been raised in other states, many of which have said, yes, this theory will be allowed. Some courts have said, no, this theory will not be allowed. You write on a clean slate. Well, a student in law school might well ask, how do you bring it about that the issue is injected into the case? As experienced hands, you know how. You submit a request to charge. With your honor, charge the jury as follows, and you give the judge the language of 402A of the Restatement Second of Torts. And you maybe adorn your request with a citation to a California case or a New York case, adopting that theory as part of the law of those states. Now it's in the case. If the judge grants the request, he charges the jury in that fashion. If you win, the other side appeals, and there's the issue in the case. Was it proper so to charge the jury? If the judge denies your request and the other side wins, so you appeal. And analytically, it's the same thing. The issue is in the case. Should the judge have charged the jury in accordance with the restatement? That function of the request to charge is known to all lawyers. What dawns upon people after a couple of years of experience in the real world of the courtroom is that, by contrast with the impression you get in law school, very few cases are legally controversial. You know, the impression you get in law school, because of the way law school case books are put together, is that every single case is an enormous case on the law. In law school, the impression you get is that every civil action is at least Erie against Tompkins. And every criminal case is nothing less than Miranda against Arizona. And out in the real world, you discover that ain't so at all. I doubt that it's once or twice in 20 years that a lawyer will run into a case involving major legal problems. I mean, if I defend a federal bank robbery case, I don't quarrel with the statute that says it's a bad thing to rob a federal bank. Who am I to quarrel with that? Of course that's the law. And as to the ground rules by which we try the case, I'm willing to accept the federal rules of criminal procedure. And as to the federal rules of evidence, I grapple them to me with hoops of steel. I have sweat blood to get to be familiar with them. I don't want to reject them. The one thing this case is about is the question, can the prosecution prove beyond a reasonable doubt that my client participated in the bank robbery? That's the issue in the case. In short, the case turns on facts, not law. That's what I mean when I say it's legally uncontroversial. The request to charge is a device of enormous utility to lawyers in precisely those cases, most of them, that turn on the facts, not the law. They are of enormous utility to lawyers in connection with their summation or final statement to the jury in cases which turn purely on the evidence, not on the application of rules of law. That's an aspect of the request to charge widely overlooked. What I will do, because I think it makes better sense, is reserve my discussion of that second aspect of the request to charge for approximately 4:45 this afternoon, when we will be discussing summations or final statements. So what you might do now, if you are taking very careful notes, is say on your paper something like, second aspect of request to charge, see summations infra. And then at 4:45, when you will long since have ceased to function up here, but your hand will be working automatically, I will simply tell you to write C supra. And when you read it over at some time when your mind is clearer, the whole thing will hang together with an exquisite perfection. Fifth and last of these preliminary matters, an important procedural opportunity which I want to be sure to discuss adequately, because so far as I know, it is nowhere codified. This is part of the unwritten law of procedure in every state court and every federal court in the land. It is called the motion in limine. A little bit of Latin, easy enough. The motion in, I-N, new word, limine, L-I-M-I-N-E. Because very few people study Latin anymore, permit me to translate it for you. It's really rather charming. Literally translated, it means the motion at the doorstep. It is a motion which you make. I've never heard of it made on papers. It's always done orally, though on the record, to be sure, not in the presence of the jury. And what it is a request for a ruling in advance, typically on some problem of evidence. And when I say in advance, I mean before the trial actually starts. So, rather than talk about it, let me illustrate it or enact it. Right? You've selected the jury. We're now in with the judge. Many judges, by the way, will say something like, do you have a motion in limine, or any motions in limine? They invite you to, or remind you to make the motion if you have it. Right? Any motions in limine? Yes, Your Honor. Has Your Honor had a chance to read the trial memorandum I submitted late yesterday? Yes, I have. Well, Your Honor will recall then that I'm going to put a witness on who will be asked the question, what color was the light? And his answer would be, well, I didn't see it, but my wife cried out, my God, the light is red. Now, Your Honor, I'm offering that to prove the truth of what it asserts. I concede that it's hearsay. I know that my opponent will object on the ground of hearsay. I urge that it's admissible as an excited utterance. May we have Your Honor's ruling now. And do you see why? Why you'd want the ruling now? You're going to open to the jury in 10 minutes. You don't want to mislead that jury. Of course not. Remember Joe DiMaggio. You must never mislead the jury. If you're not going to be allowed to prove it because the judge is going to sustain the objection, you won't talk about it. But if you are going to be allowed to prove it, you will talk about it. So, Your Honor, will you tell me, am I going to be allowed to prove it? Give me your ruling. And the judge's response to your request for a ruling may take any of three forms. First, I acknowledge your right to make a motion in limine. You've made it. Here's my ruling. Objection sustained. So it's not in. And you will handle the opening accordingly. And you'll argue it on appeal if it becomes appropriate. Second, I acknowledge your right to make a motion in limine. You've made it. Here's my ruling. Objection overruled. So it's in. Same comments. You'll handle the opening accordingly. The other side will raise it on appeal. Third, I acknowledge your right to make a motion in limine. You've made it. But you have no right to my ruling. Whether I give you a ruling in advance is discretionary with me. And I want to tell you, I am a common law judge. It's all I know. I don't rule in advance, hypothetically, or in the abstract. I wait until the situation is concretely before me, when there is a need for a ruling, and then I give you the ruling. So, I deny your motion in limine with leave to renew it when the question is asked in front of the jury. And the way you renew it is to say, I object. Well, that's what the judge wants to do. That's what he does. No one will quarrel with your right to make the motion in limine, but there's no obligation on the part of the judge to give you the ruling, though many judges will. For those of you who've never been involved in this, your temptation when the judge says, I'm not going to give you the ruling, if you're the lawyer who's got us open to the jury, will be to say to the judge, but Your Honor, I don't want to tell the jury in my opening anything that I'm not going to be able to prove. What should I do? Because you're not telling me whether I'm going to be able to prove it or not. What should I do? And the judge's response, of course, will be something like, Charlie, I no longer practice law. Right? You do what you want to do. And you fump it as best you can. I mean, all of us have been in that spot, which brings us to the opening statement. The jury is now in the box. They've put their hats and coats away, they've smoked their cigarette, and they lean forward expectantly. Don't disappoint their expectations. The opening statement is an insufficiently appreciated part of the trial. It is of enormous importance. It is a tremendous opportunity for advocacy, but at the same time, something very difficult to do well, for reasons that we will talk about. It is my impression that a lot of lawyers do not understand the importance of the opening statement. They will deliver an opening statement, to be sure, but they kind of sleepwalk through it. It's as if they're doing it pro forma. It's boilerplate. They're not really doing it with the kind of psychic energy that they will bring to bear on the summation, on an important direct, or on an important cross-examination. I say this for rhetorical effect. I don't really like to make statements of this kind, but just to get your attention. You can win your case on the opening statement. That's how important it is. A couple of years ago, more than a couple of years ago, many years ago now, two scholars at the University of Chicago set out to see whether they could acquire information about something we lawyers talk about, but in fact know nothing about. And that is what actually happens in the jury room. What persuades a jury? We all have anecdotes, we all have intuitions about it, but we have no information really worth talking about concerning what it is that decides cases, even though we and our professional cousins in England have been trying cases in accordance with our system for centuries and centuries. The two scholars were Harry Calvin, a professor of law, now deceased, and Hans Zeisel, a professor of sociology, who is still around. Their work is, or the major part of their work, is summarized in a volume called The American Jury, which is cited in the pamphlet. It is kept in print by the University of Chicago Press. It's available in paperback when last I looked, and you might want to pick it up sometime and take a look at it. Remember, it's sociology. You therefore cannot read it from beginning to end. It is literally unreadable. But every once in a while, you might want to take a look at this chapter or that chapter and get a sense of the data that they worked up and the lessons that they derived from that data. One of the things that Calvin and Zeisel set out to do was to come up with an answer to the question, how important is the opening statement? And in very simple terms, this is the experiment that they devised. They took a run of real cases in the circuit court, that's the general jurisdiction trial court, of Cook County, Illinois, that's Chicago. After the jury returned the verdict, Calvin and Zeisel interviewed each juror. And among the questions they asked the juror was, think back, sir or madam, to how you felt about the case immediately after the opening statements. Suppose you had been allowed to vote your verdict on the opening statement, without any evidence, without summations, without the judge's charge. What would your verdict have been? They then collated the answers to that final question in order to produce the hypothetical verdict that would have been returned by this jury on the basis of the opening statement alone. And they then compared that hypothetical verdict with the actual verdict returned after the evidence, final argument, charge of the judge, etc. And do you know what the correlation was? 80%. 4 times out of 5, the hypothetical verdict was substantially identical with the actual verdict returned at the close of the case. That's in part what I had in mind when I said you can win on the opening statement. If the Calvin-Zeisel study is correct, there are flaws in the design of the experiment, but I do think it's essentially correct. If you deliver an opening statement that leaves the jury inclined to decide the case your way, 4 times out of 5, they will decide the case your way. And those are very good house odds, let me tell you. The reason I think that their study is pretty much correct is that it's consistent with my own intuitions based upon dealing with people in private life, not in the courtroom. And you've all had the same experience. You're talking to a spouse, to a friend, to a child, to a parent. You've got to convince them of something. The person you're talking to has a genuinely open mind. What are the chances of your convincing them? I guess statistically it's 1 out of 2. But now contrast that with another experience that we've all had. You're talking to spouse, friend, child, or parent. But that other person does not have an open mind. He has at least tentatively made up his mind, so that your task is not so much to convince him as rather to persuade him to change his mind. That's very different, isn't it? What are the chances of persuading somebody to change his mind? Offhand, I would say no better than 1 out of 5, because of a truth of human nature. When someone has made up his mind, he tends to dig his heels in and resist any attempt to make him change his mind. Because to change your mind is to confess fallibility or error. And human beings do not like to confess fallibility or error. The judge can charge the jury until the judge is blue in the face that they're to keep an open mind. It is contrary to human nature that a jury can listen to an account of the trial and keep an open mind. It can't be done. Having heard the opening statements, the jurors tentatively make up their mind. They say to themselves, it's only tentative, I'll change my mind if the evidence warrants it, etc., etc. But they have made up their mind, albeit tentatively, which means that if they've made up their mind against you, your task is not to convince them, but rather to persuade them to change their mind. And your chances of doing that are slight indeed. And that's my intuitive reading of what the Calvin-Zeisel statistical study seems to suggest. That if you can deliver an opening statement that leaves the jury anxious to decide the case your way, well, you're 80% of the way home to a victory. Given the importance of the opening statement, there are two practical suggestions that I derive from it. Okay? The first, I don't think there'll be any quarrel about. Never waive your opening statement. If you are trying the case to a jury, deliver an opening statement. Even though you don't have anything to say, don't go down without a fight. Do your best to say something to the jury, even though you know very well you're not going to be able to persuade them, however tentatively, to decide the case your way. Remember I said before, in the long run, you only bat 500. Well, the only way to bat 500 is to play every trial to win. And then you're going to lose half of them. But if you play some of them not to win, you're not going to win your share. So even though you don't seem to have a defense, even though there's nothing to be said in the opening statement, try. I address the youngsters in the room. Some of you probably work for criminal defense, public defender operations, things of that kind, and you do the sort of work that I did in my time, and it's in that position that you will be especially tempted to waive the opening statement. You are defending a case where we understand you've got a professional obligation to defend it, but there is in fact nothing to be said on your side of the case. And so you don't want to try to say anything to the jury, because if you were to stand up and speak the truth to them, this would be your opening statement. Good afternoon, ladies and gentlemen. There he is. He did it. He planned to do it. He enjoyed it while he did it. And if you give him another chance, he will do it again. Thank you. And you sit down. That is an absolutely truthful opening statement in most criminal cases. But we, vibrating as we are to the special obligations of an advocate, we understand that you can't deliver that kind of an opening statement. So you deliver the opening statement that really doesn't amount to very much, but still, at least you go through the motions. You can always detect such an opening statement. Any opening statement that includes a reference to the American jury system is such an opening statement, right? Any opening statement that includes the line, I envy you, your privilege serving on an American jury, is such an opening statement, and so on and so forth. My second practical suggestion is more controversial in that lawyers of experience may well disagree with me. I don't know what your local practice is, but I'm sure you've got something like this. If you are the defendant in either a civil or criminal case, normally you would deliver your opening immediately after the prosecutor or plaintiff opens. But if you ask the judge for leave to reserve your opening until next week, just before you put in your side of the case, the judge will grant that application. Reserve the opening so that you deliver your opening with reference to your case the way the plaintiff delivers the opening with reference to his case, right at the beginning. My advice is not to do that. Two reasons. There are more than two reasons, but I'm only going to talk about two. First, a reserved opening, as the jury hears it, lacks something of sincerity. And remember, you must test or judge all of your proposed gambits. Everything that you want to do in that courtroom must be tested and judged from the jury box. See it with the jury's eyes, hear it with the jury's ears. The jury is unsophisticated in our litigation system. The jury, by and large, regards the trial as a search for the truth. We know that it's not, but the jury thinks that it is. The truth is the truth, today as well as next week. Why, the jury says to itself, did defense counsel reserve his opening statement? It must be that defense counsel wanted to hear the plaintiff's evidence so as to temper or modify his opening statement precisely to match the evidence that the plaintiff is offering against him. Isn't that astute of them? That's exactly what you're doing, within the foul lines, of course. You will adapt the defense to the strengths of the prosecution or the plaintiff's case. But to the jury, that's inconsistent with the search for the truth, because the truth is the truth. And if you are adapting your case to meet the strengths of the other side's case, you're not putting on a truthful case, you're putting on a lawyer's pettifogging case. And they begin to distrust you, and you're on your way to losing. Second, here again I draw my analogy to the theater in a way different from what I did a little bit earlier, an analogy we'll be using again and again in the course of the afternoon. This is a little different in that, well, in this respect. In my view, you try your case to the audience presently before you, and that's the audience in the jury box. If you try the case well, with a certain amount of technical proficiency, you don't have to worry about it on appeal. The appeal takes care of itself. Very few cases are reversed on appeal. Win it now. Don't be unduly concerned with the appeal. That's my view. That being so, whatever expectations this present audience has of you, you must be sure to fulfill. You play it to this audience, not to the audience of next year that may be sitting in the appellate court. It is part of your obligation as a trial lawyer to become familiar with the expectations this audience has of you. And you know how you become familiar with their expectations? Honest to God. Go to the movies and watch television. There are an enormous number of movies and television programs about trials. You must make it your business to see every single courtroom movie that comes out and watch at least a sampling of the television shows about lawyers. Yes, not because you're going to learn anything, I'm not so sure that you will, but because the jurors are watching those movies and television programs and acquiring what they think is an understanding of how trial lawyers are supposed to try cases. And you'd better not do anything too different from that. If you do something very different from what they see in the movies, you know what they will think? You don't know your business. And if you don't know your business, why should they trust you? And if they don't trust you, you're on your way to losing the case. Have you ever seen an opening statement in the movie? Sure. Anatomy of a Murder. George Scott opened for the prosecution, and Jimmy Stewart instantly opened for the defense. He did not reserve his opening. So that shows the jury that an able defense lawyer never reserves his opening. You always deliver it immediately after the plaintiff or the prosecutor, because after all, there's nobody better than Jimmy Stewart. I agree, there is nobody better than Jimmy Stewart. So you better do it the same way Jimmy Stewart does it. All right. So much on when to do it, etc. Think about it. If you disagree, so be it. But I do believe what I've told you. What's the purpose of the opening statement? Well, we've been given the purpose of the opening statement time and time again in appellate opinions. The purpose of the opening statement is to outline for the jury the nature of the case and your position in that case. Somewhat more plainly put, as trial judges tend to say it, the purpose, the function, the office of an opening statement is to outline for the jury what you intend to prove. And the most important part of that is what's excluded by implication. The opening statement outlines for the jury what you intend to prove. It is not the occasion for arguing the case. You may not argue on the opening statement. That's universally applied law in America and indeed in England. If you argue in the opening statement, there will be an objection, and many judges will interrupt on their own and tell you to stop arguing. And you can argue in either of two ways. First way, overt argumentation. Something like this. Ladies and gentlemen, I'm going to call a witness who's going to tell you ABC. The other side's going to call a witness who's going to tell you XYZ. Now, between ABC and XYZ, which one is likelier to be the truth? Objection, he's arguing. Sustained. See? Because you're asking the jury to decide between the two contending witnesses. Another way of arguing is not overtly, but implicitly with tone of voice. If you raise your voice sufficiently, you're arguing. If you yell a little bit, you're arguing. And if you cry, you are arguing. Who am I to disagree with appellate opinion after appellate opinion? You are not permitted to argue on the opening statement. That is our obligation as officers of the court. Simply as tacticians, you don't want to be interrupted at that early stage of the trial with an objection that the judge is going to sustain. And certainly, you don't want to be interrupted by His Honor himself telling you that you're doing something improper. That's no way to get off on the right foot with the jury. But now, wait a while. Isn't that intriguing? Isn't that difficult? The purpose of an opening statement is to persuade the jury to decide the case your way. And yet you may not argue on the opening statement. How then can you deliver an opening statement that leaves the jury desperate to decide the case your way, and yet never once elicit that objection, he's arguing? That's the difficulty of it. It's also the fascination of it, and it's the fun of it. You can't do it every time out, of course not. You're only going to bat 500, but when the gods are kind and you're having a good day, it's possible to deliver an opening statement that never once will elicit the objection he's arguing, and yet leaves the jury anxious to decide that case your way. Now how? I have some suggestions, and lest I be more than usually confused, let me tell you what I'm going to do. My first 4 or 5 suggestions, it seems to me, are totally uncontroversial. Nobody will disagree with them. Nevertheless, I want to go over them with you because they're very important. That's precisely why everybody agrees with them. And after we go over those first 4 or 5 non-controversial suggestions, I will give you what I regard as the essence of the key to resolving the problem of the opening statement. How to persuade, but at the same time, never argue. Right? The uncontroversial things first. Number 1, the opening statement must be prepared. You cannot wing it. It cannot be extemporized. You prepare it in whatever way is consistent with your work habits. On that I have nothing to say, but prepared it must be. Second, as part of the preparation, no matter what your work habits, you must rehearse it. And by rehearsal, I mean at least one actual speaking of the opening statement. Now, whether you're going to say it to a moot jury made up of associates in the office, whether you're going to say it to somebody at home, whether you're going to say it to a mirror, whether you're going to recite it into a tape recorder and then listen to a playback, or like the fellow who delivered the keynote at the Republican convention. Apparently, he walked around the woods and recited it to the trees. Whichever way you do it is all right with me. But you must say it for reasons known to every beginning actor, but apparently unknown to many lawyers who ought to know better. Remember, this is oral expression. This is not something you write. It's not something the jurors read. You must say it so that the jurors listen to it. You know what the analog is? The analog is dialogue, that an actor must recite and the audience must hear. I wonder if any of you has any experience with this kind of thing. You're about to do a new play. You're one of the actors. You sit down for the first day of rehearsal. You're going to have 4 weeks of rehearsal. There's Edward Albee, the author. There's the director. And what do the actors do on the first day? Do you know what the actors do on the first day? They just sit on chairs and they read it through out loud. And you know what they're looking for? They're looking for something, it's not very mysterious, all of us know it. The spoken language is different from the written language. Something that reads smoothly in print on paper may not speak smoothly because of the physics of speech and just the ordinary rhythms of the English language. So that if you were to be present at such an initial read-through, an actor might come to a speech, he tries to read it, has trouble, turns to the author, and he says, Mr. Albee, it's a terrific scene. And the idea of this speech is terrific. It's going to bring the house down. It's going to electrify the audience, but it doesn't speak. That's the actor's expression for it. It doesn't speak. Would you rewrite it, Mr. Albee, so as to convey the same idea, but in a form that's easier to say? Do you remember Hamlet talking to the player king? Speak the speech as I pronounced it to you, I pray, so that it falls trippingly from the tongue. Falls trippingly from the tongue. Get the idea and the sound. How easy it is to say that. Falls trippingly from the tongue. If I haven't gotten my point across, when you go home tonight, in addition to the Sherlock Holmes story, take out any play by Oscar Wilde or Bernard Shaw. It's prose, it's modern English, there's no difficulty with the meaning. Read through any page of dialogue. Read it out loud. Don't try to act it, just read it. Those two men are the ultimate masters of actable dialogue. Read it and get a sense of how easy it is to say the sentences. How it's so natural because it's so congruent with the native rhythms of English. And then pick up any advance sheet selected at random. Now, obviously, it's not meant to be read out loud, and that's why the contrast is so great. Open it to any appellate opinion and read any paragraph. Any paragraph. And you will find that it's almost impossible to say. Truth to tell, it's impossible to read also. You know, what is this? But you certainly can't say it, well, because it's not written to be said. My point is that it's very unsettling to be on your feet in front of the jury, delivering an opening statement which you have prepared, to be sure, but not rehearsed, and suddenly you hit a rough spot, a part that does not speak. It just doesn't come out smoothly. And you've got to stop and interrupt yourself and work it out right there in front of the jury. And what it gets across to the jury is a certain lack of professionalism, a lack of preparation, a certain amateurism, all inconsistent with the Joe DiMaggio idea, and you're on the way to losing that case. Prepare it, rehearse it, and when you are ready, stand in front of the jury and talk to them. No notes. Yes, no notes. For young lawyers coming to this for the first time, they can't believe it. But I really mean it. And I don't think there's any experienced hand who will disagree. No matter how good you are, if you are accustomed to working with notes, you will be better if you work without notes. And by notes, I mean just about anything. No script. Don't read it, for God's sakes. Not even an outline. The most I will allow is a 3x5 card. There may be dates. Dates are important. Not the chronology of events, that you can carry in your mind, but particular dates. Very few of us can remember that. You might want to jot down a couple of dates. If numbers are important, specific amounts of money, you might want to jot that down. This is a problem I have great difficulty remembering people's names. So I write down the names of all the witnesses and the characters and so forth, so I don't draw a blank on that. And beyond that, stand up and talk to them. I'll mention only one reason for doing so. Your purpose when you stand there is not to deliver an opening statement that will read perfectly in the record. Your purpose when you deliver an opening statement is to persuade these jurors. How do you persuade? The law student would say, well, you persuade with ideas and arguments and intellect and the products of thought. And the answer is no. That's not entirely unimportant, but it's at the bottom of the list. You are there in person in front of those jurors. You are in their presence. You know what's more important than the ideas? You. Everything about you. The way you look, the way you stand, your voice, the degree of commitment to your cause that you communicate to the jurors, and of everything about you. What is potentially the most persuasive part of you? The face. And what in the face will be most effective at persuading the jury? The eyes. You don't have to work at it. You just have to let the jury see your eyes. If you've got a script in front of you and you read from it, the jury sees your eyes only 1 second out of 10. You've taken away 90% of the most important thing you have going for you. If you work from a detailed outline, and let's say 3 seconds out of 10 your eyes are down on the page, 7 seconds out of 10 they're on the jury, you've deprived yourself of 30% of the most important thing you have going for you. Let it work for you 100%. Let the jury see your eyes. And I have absolutely no doubt that I'm right on that, but I have a marvelous citation. I have authority on it. I must tell you that one of the things I do with my spare time, or began to do a couple of years ago, I decided to read or reread all through the classical writers on oratory. By classical, I mean ancient times, Greece and Rome. And oratory, to a Greek or a Roman, meant essentially litigation. What lawyers do in the courtroom, in the legislature, before the administrative committee, etc. So that De Oratora, by Cicero, is best translated not as about speech making, but as about litigation. There are 4 principal writers of antiquity on oratory, 1 Greek, Aristotle, and 3 Romans, Cicero, Pliny the Elder, and Quintilian. A total of about 12 volumes, and I'm almost through with it, and then I'm going to write something on it to show that everything we think we know, they knew 2,500 or 2,000 years ago. Cicero's De Oratora is a book, the form of which is an old hand talking to the youngsters. That's how he does it, and an experienced litigator talking to young lawyers. There is 1 chapter in book 2 in which, and when I read this, the hair on the back of my neck stood up, because it's Cicero talking in, well, the year approximately 40 of our era. So it's 1900 years ago, 1940 years ago. He said, "Hey gang, when you talk to the Senate or a jury, your job is to persuade. And what you have with which to persuade them will be ideas, yes, but that's least important. More important than ideas is you, all of you, your posture, what you look like, your voice, etc. The most important part of you, your face. The most important part of your face, your eyes. Therefore, fellas, don't use notes. Just look at them and talk." Cicero said it, and I'm saying it too. So you better take it to heart. No notes. Next, you prepare, you rehearse, no notes, and I now return to something I promised to return to. Speak plain English. Remember, we talked about it in connection with the jury selection. No prior tos, no subsequents, no motor vehicles. All before, after, car, etc. Now, in connection with jury selection, the reason I gave for speaking plain English is that you want the jury to understand you. Same reason applies. You want the jury to understand you. But I now add a different reason. And here, I tell you, we're beginning to get beneath the surface of things, but I regard this as important as anything else. Pause. Think with me a bit. The burden of my sermon is that you're going to do well in court in direct ratio to your success at persuading the jury that you are trustworthy, Joe DiMaggio, etc. Do you realize what a hard thing that is to do? You know why it's hard. You're talking to a jury, not to fellow lawyers or judges. You're talking to a jury. They are lay people. They are outsiders to the profession. They know that you are a lawyer. They therefore know that you are a rascal, a villain, untrustworthy, etc. And I'm telling you that your job is to persuade them to trust you. That's against the grain. It's an uphill task. And you expect me now to say that it's against the grain, it's an uphill task, because we live and work in the post-Watergate era. I say no such thing. It evinces a profound ignorance of the Western intellectual tradition to say that since Watergate, lawyers are held in low esteem by the public at large. It is no small part of our history that lawyers have always been held in low esteem by the public at large. The quotation is hackneyed because they used it so much during Watergate. But do you remember Shakespeare, Henry VI, Part 2? That's 1586 talking. Jack Cade's rebellion breaks out. Remember, Dick the Butcher is leading the rebellion, and what does he say? Quote, "First thing we do, let's kill all the lawyers," close quote. That's 300 some odd years ago, 400 years ago. Let's bring it up to date. What about the American man or woman in the street? Nobody reads much Carl Sandburg anymore. Not a very good poet, a much better biographer of Lincoln. But as a poet, he struggled all his life to give a poetic voice to the outlook of the man or woman in the street in small-town America. And the one volume in which he probably came nearest to success is called The People, Yes. And in The People, Yes, Sandburg writes 2 lines which convey what the man or woman in the street thinks about us, the lawyers. I quote Sandburg. "Why is there a secret singing every time a lawyer cashes in? Why does the hearse horse snicker, hauling a lawyer away?" You stand up and you say to those jurors, "Ladies and gentlemen, I'm an attorney." And their instant response is, "You're a crook." Well, next point. How can you persuade them to trust you even though you are a lawyer? And you know what my answer is? You can't say this to them, but you've got to get this idea across. Ladies and gentlemen, I can't fool you. and I won't try to fool you. Yes, I'm a lawyer. It's a misfortune in my life. I didn't want to be a lawyer. My mother made me go to law school. Right? I'm basically an honest fellow trying to do an honest day's work. Please put it to one side that I'm a lawyer and forgive me. Every time you use highfalutin language to that jury, do you realize what you're saying to them? You're saying to them, hey, never forget it. I'm a lawyer. And as every time you say that, their degree of trust in you goes down. The way to get across the idea that it's a mere accident of fate that you're a lawyer, but basically you're an honest man, is to speak plain English. Really, work very hard at ironing out of your vocabulary all of the lawyerisms. Let the other guy use the lawyerisms. Let the other guy paint himself with the brush of being a lawyer, and he loses the case himself. Right? As a matter of fact, let me put that together. This is kind of forbidden knowledge. I don't like to lean on it too hard, but I've told you I don't believe in attacking the other lawyer. No, that's just sort of against the credo that I profess. But if it's one of those rare occasions when you must attack the other lawyer, when the guy's been pushing you too far and you think you have to hit back, do you realize the most effective thing to call him? Don't call him a liar. Don't call him a snake. Don't call him a scorpion. Don't call him a moral serpent. Call him a lawyer. Right? Call him a lawyer and you will blast him right out of the water. Let me give you an example. The opening statement is low-key. We understand. Assume it's the summation. Okay, it's the summation. And you've decided to really do a job on your opponent because he deserves it. See, he's earned it. He's brought it on himself. You don't do it just out of principle. Ladies and gentlemen, here we are at the summations. It's the final stage of the case. And a remarkable thing has happened. I think you know what it is. You remember in the opening statement 3-4 days ago? I know you remember because I saw you paying strict attention. I saw you note the remarkable thing that Mr. Smith said in his opening statement. And I thought it was so remarkable that I wrote it down on my yellow pad. Here it is, his exact words, and I know you remember him saying it. Mr. Smith said, yes, you said it, Mr. Smith, you did say it. He said, quote, I am going to prove to you that the light was red, close quote. That's what he said. Now here we are at the end of the case. There are no more witnesses, all the witnesses have testified. There are no more exhibits, everything is before you that's going to be before you. You have every bit of proof that there isn't one shred more of proof. And is there one syllable before you to show that the light was red? Not one. And that's the kind of case he's put in. No evidence, no proof, all lawyer talk. Case is over. Just sit down, that's it. Case is won. Why? Because he's the lawyer. And as between a lawyer and a non-lawyer, the jury will always go with the non-lawyer for reasons having to do with the history of Western civilization. That's what you're writing on. Next, still preliminary, and it seems to me beyond controversy. An aspect of the Joe DiMaggio image that we mentioned but have not developed, and I'm going to develop it a little bit, is the idea that one of the ways you get the audience to trust you is by showing the audience that you are a complete professional. That, well, to continue with DiMaggio, when DiMaggio played center field, you had the idea that this was what a professional man or woman looks like, doing the thing he has been training himself for years to do. That's that subtle excitement of making it look easy, taking something very hard and making it look as if you do it almost by force of nature. That kind of professional competence is very important to get across to the jury. It is why you should ideally never let the jury sense that you don't know what you're doing. It's why, to go back to the very beginning, you would never in front of the jury say to the clerk, how do I do that? Or say to the judge, Your Honor, I guess I'm confused here. Never. Because if they think you don't know your business, they may sympathize. They won't dislike you. But they won't trust you. Not because you're morally untrustworthy, but because you're professionally untrustworthy. Now that has a very important implication for the opening statement. One of the ways in which you get across to the jury the idea that you are a true professional is to convey your mastery of the case. You control the case rather than the case controlling you. You've got that case, the facts of it, I mean, in the palm of your hand, rather than the facts overwhelming you so that you're barely keeping your nose above water and you're probably going to drown by the time the case is over. Hence the importance of organization, hence the importance of control, and hence in the opening statement, the need to have a form. Now, the opening statement is a literary genre, a humble one to be sure, but a literary genre. It must have a form, some principle of organization. Now, that principle can be very simple, but it's got to be there. You have to know what it is. The jury will not know what it is, but they will respond to it. And you know what their response to it will be? That lawyer knows his case. He's in control of the case, which is part of their coming to trust you. It seems to me that the appropriate form of an opening statement is not a very complicated thing. Here, I'm just helping myself to what I found in one of my authorities. It's probably the profoundest thing that was ever said about literary form. It was said by Aristotle. He was talking of the form of Greek tragedy. But what he said of Sophocles is equally true of your next opening statement. You will find it in the Poetics. Aristotle said that a Greek tragedy should have a beginning, a middle, and an end. Isn't that wonderful? It took Aristotle to say it. A beginning, a middle, and an end. How many opening statements have you heard that did not rest upon that form? I vividly recall an opening statement delivered by a lawyer acquaintance of mine in a case over which I presided. And I actually kept track of it. I don't have my notes with me, but this was essentially it. It began with the middle, then went to the beginning, then to the end, then back to the middle, then to the end again, then to the beginning. And when the guy finally sat down, he had delivered 4 opening statements in shuffled sequence. There were 4 openings, 4 middles, and 4 conclusions, all mixed together. And when the case was over, I said to him, "Charlie, do you know that you delivered 4 opening statements?" And he said, "Yes, I did know it." And I said, "Why did you do that?" And he said, "You know, I was so excited and nervous that I couldn't stop." The jury sensed that. He was excited, he was nervous, nice guy, got to sympathize with him, but for heaven's sakes, you don't trust him. I mean, the kid shouldn't be doing this kind of work. He's just not up to it. He has not mastered his case. You will communicate that necessary mastery by delivering an opening statement with a beginning, a middle, and an end. The beginning is perhaps the most important part. I take that back. The beginning is a very important part whose importance is insufficiently appreciated. I think I can get across to you the nature of the importance of the beginning by again referring to the theater. Remember earlier in the day I said that to the jury, every single trial, even if it's only a half-day property damage hit in the rear case, is a very complex story with an enormous amount of information to be absorbed. Well, of course it is. And observe the jury's situation, their plight, if you will. The jury must acquire all of this information, and they do it by listening and watching. They don't read it. They don't read the pleadings. They don't go through the discovery with you. They have not lived with the case as you have. They're just hearing it once, right now, for the first time. What's more, the very lingo that we take for granted is a little bit foreign to them. Did you ever stop to realize words like plaintiff, defendant, prosecutor, defendant, intersection, left turn, witness, document, exhibit, all of those things are just a little bit strange to the jury, and they require a certain amount of energy to absorb, to learn. And fatigue can set in very easily. The jury, in order to understand the line of the case as it develops, must have at the very beginning a fair amount of information. Essentially the who, what, where, when, why. Who's involved? What's the problem? Where are we? What's going on? That's the office of your beginning of the opening statement. Give the jury that necessary preliminary information. and give it to them so that it sinks in, so that they absorb it. The very same task is faced by a playwright who, remember, assumes an audience sitting there on opening night. They know nothing about what's going to unfold on stage. In order to follow the unfolding of the plot, the audience requires a certain amount of information preliminarily. Who, what, where, when, why. In playwriting, that is called the exposition, and it must come at the beginning of the play. You've got to get across to the audience what's going on. A couple of examples. Many of you have seen a Kaufman and Hart comedy, an amateur, if not a professional production. You know, New York, 1930s, early 1940s. That's hack playwriting. Those are not plays of genius, but it's hack playwriting at its highest form. Kaufman and Hart, Kaufman and his other collaborators were ultimate professionals. How many of you have ever seen one of those plays? You know how it begins. The curtain goes up. Well, we don't know where we are. We don't know what's going on. We're looking at a middle-class living room, center stage a table, on the table a telephone. Nobody is on stage. The telephone rings. Enter the maid. She picks up the telephone and has a conversation. We hear only the maid's side of it. It's the exposition. By the time she puts down that telephone, we know where we are, what the problem is. We have the necessary preliminary information. You haven't seen a Kaufman and Hart comedy? When you go home tonight, in addition to Doyle, in addition to the other things I've told you to read, take out your volume of Shakespeare and spend 5 minutes reading the greatest exposition ever written. Act 1, Scene 1 of Hamlet. Imagine what it must have been like on opening afternoon. It was not opening night, it was opening afternoon, right? Nobody ever heard of this play before. It's a new one. Nobody had ever seen it. Nobody had ever read it in high school. Nobody had ever seen it in the movies, right? Well, I read it, I purposely pick it because we've all read it. Do you realize what a complicated situation that is at the beginning? It's so complicated that you want to laugh at it. First of all, it's in Denmark. Whoever heard of Denmark? Right? It's in Denmark. And the old king is dead in suspicious circumstances. And what's more, the new king is the dead king's brother, and he has actually had the temerity to marry his brother's widow. And the young Hamlet, the dead king's son, is some kind of lunatic, come home from school to attend his father's funeral and his mother's wedding. And on top of all that, there are reports of a ghost walking around the tops of the towers, apparently the ghost of the old king. On top of all of which, Norway, seeing an opportunity to make some political progress here, seems to be raising an army, perhaps with the intention of invading Denmark. All of that we must know in order to follow the play.